On February 19, 1942, President Franklin Roosevelt signed Executive Order 9066. The order authorized the Secretary of War to designate military areas from which any person could be excluded. It did not name Japanese Americans. It did not use the word internment. It did not mention property. It was 11 sentences long. Within months, 120,000 people, approximately two-thirds of them American citizens by birth, had been removed from their homes on the West Coast and transported to detention camps in the interior of the country. They were given between 48 hours and 2 weeks to report to assembly points. They could bring only what they could carry. Everything else stayed behind: the farms, the fishing boats, the grocery stores, the flower nurseries that Japanese Americans had built into the dominant industry in parts of Southern California, the houses, the furniture, the cars, the bank accounts in some cases, the crops in the ground, sometimes days from harvest. Everything else stayed behind, and the records of what happened to it are in the National Archives, in the Federal Reserve Bank of San Francisco's Historical Archives, in the California State Archives, and in the files of the Farm Security Administration. I have been reading those records. What they show is not what the official history of Executive Order 9066 emphasizes. The official history focuses, appropriately, on the civil liberties violation, the removal of citizens without charge, without trial, without due process. That story is real and important and has been told. What has been told less thoroughly is the property story, the specific, documented, financially detailed account of what happened to what was left behind. To understand the scale of the property loss, you need to understand what Japanese Americans had built on the West Coast by 1942. The Issei, the first generation, born in Japan, legally barred from citizenship by the Naturalization Act of 1790, which restricted naturalization to free white persons, had spent decades building agricultural and commercial enterprises under conditions specifically designed to prevent them from accumulating property. The alien land laws of California, Oregon, and Washington, passed between 1913 and 1923, prohibited aliens ineligible for citizenship from owning agricultural land. Because Japanese immigrants were legally barred from citizenship, they were legally barred from owning land. They responded by holding land in the names of their American-born children, by leasing rather than owning, and by specializing in labor-intensive agriculture, strawberries, flowers, vegetables, where the value was in the work rather than the land. By 1941, Japanese-American farmers produced approximately 40% of California's commercial truck crops. They operated 5,135 farms, covering 220,000 acres. The value of their agricultural output was approximately $35 million annually, roughly $600 million in today's dollars. This is documented in the agricultural census records for California for 1940, available through the National Agricultural Library, and in the reports of the Farm Security Administration, which are in the National Archives. When the removal order came in the spring of 1942, these farms, the crops in the ground, the equipment in the fields, the leases on the land, had to be dealt with in 48 hours to 2 weeks. What happened to them is in the records. Some farmers found white neighbors willing to manage their land in their absence under informal agreements. Some found no one willing to help. Some simply walked away from crops days from harvest because there was no other option. The Federal Reserve Bank of San Francisco was designated by the government as the custodian of Japanese-American property, the institution responsible for managing or liquidating the assets of the removed population. The Federal Reserve Bank's property custody records from 1942 to 1946 are at the Federal Reserve Bank of San Francisco's archives. They document, property by property, what was received into custody, what was managed, what was sold, and at what prices. The prices are the detail I cannot put down. Agricultural equipment that had cost thousands of dollars sold for hundreds. Furniture that had filled houses sold for the kind of prices you get when the seller has 48 hours and no choice. Fishing boats. Many Japanese Americans in California were fishermen, and the Coast Guard had ordered them away from the coast in the weeks before the evacuation, were sold or seized at fractions of their value. The Federal Reserve Bank's own records acknowledge that the prices obtained were below market value. The specific language used in internal correspondence, available in the bank's historical archives, is distress sale conditions. The bank knew the sales were happening at unfair prices. It documented this in its own records. It proceeded anyway. The total assessed value of Japanese-American property at the time of the evacuation, farms, businesses, homes, equipment, inventory, has been estimated at various points from $400 million to $2 billion in 1942 dollars. The estimates vary because the records are incomplete and because the alien land laws had structured much of the property holding in ways that made formal valuation difficult. What is documented is the gap between what things were worth and what was paid for them, property by property, in the Federal Reserve Bank's custody records. Now I want to tell you about Kojiro Oyama, because his case makes the property story specific in a way that aggregate numbers cannot. Kojiro Oyama was a Japanese immigrant who had farmed in San Diego County since the 1920s. Because he was legally barred from owning land as an alien ineligible for citizenship, he had held his 56-acre farm in the name of his American-born son, Fred, who was 6 years old when the property was purchased in 1934. The arrangement was standard for Issei farmers navigating the alien land laws. When Executive Order 9066 was signed in 1942, Kojiro and his family were removed to an internment camp. While they were in the camp, the state of California filed an escheat action against the farm, an action claiming that the land should revert to the state because it had been held in violation of the alien land laws. The specific claim was that Kojiro, as an alien ineligible for citizenship, had effectively owned the land by holding it in his son's name, violating the prohibition on alien land ownership. The escheat action was filed while Kojiro was in an internment camp, unable to attend to his legal affairs. He fought it. After the internment ended, Kojiro pursued the case through the California court system and eventually to the United States Supreme Court. The Supreme Court ruled in Oyama v. California in 1948, 6 years after the evacuation, that the escheat action violated the equal protection rights of Fred Oyama, the American citizen, in whose name the land was held. The case is in the Supreme Court records. It is Oyama v. California, 332 U.S. 633, 1948. It is available through the Supreme Court's online database. Kojiro got his farm back. Most Japanese Americans did not have the resources or the legal standing to fight what happened to their property while they were in the camps. The government's own records document this. The Federal Reserve Bank's custody records are in the bank's historical archive. The Farm Security Administration records are in the National Archives. The California escheat actions from this period are in the California State Archives. The records of the War Relocation Authority, the agency that administered the camps, are in the National Archives under Record Group 210. The records show what was taken, what was sold, at what prices, to whom. They show the distress sale conditions the bank's own correspondence acknowledges. They show the legal actions filed against property while owners were in camps. They show what was returned in the much larger category of what was not. The documents were always there. The story they tell has been assembled in parts by the redress movement of the 1980s, by the Civil Liberties Act of 1988, by the historians who have studied the internment. What has not been fully assembled is the specific property account, farm by farm, business by business, the gap between what Japanese Americans had built by 1942 and what they were able to return to in 1945 and 1946. That gap is in the Federal Reserve Bank records. It has been there since 1946. In the spring of 1945, the War Relocation Authority began issuing notices to Japanese Americans in the internment camps that they were free to leave. Most of them had nowhere to go. The farms were gone, sold, leased to others, sometimes seized under escheat actions. The fishing boats had been sold or were in disrepair after 3 years of neglect. The grocery stores and nurseries had been taken over by other operators. The houses had been rented to other families. The bank accounts in some cases had been frozen or spent on camp administrative fees. The War Relocation Authority's own records document what they found when they surveyed the returning population's economic situation. The survey is in the National Archives under Record Group 210. It describes, in the dry language of government assessment, the specific economic condition of people returning from 3 years of detention to find that the property economy they had built over decades had been dismantled in their absence. The survey is not rhetorical. It does not use words like injustice or dispossession. It uses words like unable to resume former occupation and property unavailable for return. These phrases appear thousands of times in the survey records. I want to tell you about a woman named Toyo Tsuyamoto because she is in the records and almost nobody knows her name in the context of the property story. Tsuyamoto was a poet and a librarian. She had been born in Oroville, California, and had been teaching at the University of Cincinnati when the evacuation order came. She was not on the West Coast when Executive Order 9066 was signed, but her parents were. Her parents had a flower nursery in Placer County, California, that they had operated for 2 decades. When the evacuation order came, her parents were removed to the Topaz internment camp in Utah. Their nursery, the greenhouses, the equipment, the stock, the established customer relationships of 20 years, had to be disposed of in 2 weeks. A neighbor agreed to take over management. The arrangement was informal, undocumented, based on a handshake. When her parents returned from Topaz in 1945, the neighbor had sold the nursery's equipment, spent the proceeds, and had nothing to return. The nursery was gone. The land lease had expired. 2 decades of her parents' working life had been converted into nothing during 3 years in a camp in the Utah desert. Tsuyamoto's account of this appears in oral histories collected by the Japanese-American National Museum in Los Angeles, which maintains an archive of internment survivor testimony. The oral history collection is available to researchers by appointment. Her account is specific, detailed, and corroborated by the property records that can be found for her parents' address in the Federal Reserve Bank custody files. She went on to publish poetry, to teach, to have a distinguished career. Her parents never recovered their economic position. They died, as the oral history describes it, having rebuilt from nothing in their late 50s and 60s. Her story is representative. The flower nursery industry in California, which Japanese Americans had built into commercial dominance before the war, never returned to Japanese American ownership. The farms that had produced 40% of California's truck crops in 1941 did not return to Japanese American farmers in 1945. Some were returned. Many were not. The industry structure that had existed in 1941 did not reconstitute itself. This is documented in the post-war agricultural census records, in the Farm Security Administration's follow-up surveys, and in the academic literature on Japanese American economic history. The comparison between the 1940 agricultural census and the 1950 agricultural census for Japanese American operated farms in California, Oregon, and Washington is in the census records. It shows a decline in acreage operated by Japanese American farmers that was never reversed to its pre-war level. Now I want to tell you about the compensation, because the compensation story is in the records, and it is the detail that makes the property loss permanent rather than temporary. In 1948, Congress passed the Japanese-American Evacuation Claims Act. It established a process for Japanese Americans to file claims for property losses resulting from the evacuation. The total amount appropriated for all claims was $38 million. The estimated total property loss, by the government's own assessments, was between $400 million and $2 billion in 1942 dollars. The act also imposed specific limitations. Claims had to be filed within 18 months of the act's passage. Claims could not include losses of earnings, the income that Japanese American farmers, fishermen, and business owners had not earned during 3 years of internment. Claims could not include interest on the value of lost property. Claims required documentary proof of ownership and value that in many cases had been lost in the chaos of the evacuation or was impossible to obtain because the alien land laws had structured ownership in ways that left no clean paper trail. The limitations were not accidental. They were designed by a Congress that wanted to provide some compensation while ensuring that the total cost remained manageable. The legislative history of the 1948 Act is in the congressional record. The deliberate exclusion of lost earnings, the short filing deadline, the documentary requirements. These decisions and their rationale are in the committee reports and floor debates. The result was that the $38 million was distributed among approximately 23,000 claims. The average payment was approximately $440 per family in claims that had an average stated value of approximately $13,000, roughly 3 cents on the dollar. The individual claim files from the Japanese-American Evacuation Claims Act are in the National Archives. They contain the specific statements of loss, the documentation submitted, the adjudications, and the final payments. They are a case-by-case record of the gap between what was lost and what was recovered. The Civil Liberties Act of 1988 acknowledged the injustice more completely. It provided $20,000 to each surviving internee and an official apology from the federal government. President Reagan signed it. The apology acknowledged that the internment had been wrong. It did not restore the property. It did not compensate for the decades of economic disadvantage that followed the property loss. It did not address the families whose heads had died before 1988 and who received nothing. The Civil Liberties Act is in the congressional record. The legislative history documenting the debates about what it should include and what it should exclude is in the congressional record. The decision not to address the property dimension more thoroughly is in the record. Here is the question I keep returning to. The records of what Japanese Americans owned in 1942 are in the Federal Reserve Bank's custody files. The records of what was sold, at what prices, to whom, are in those same files. The records of the claims filed in 1948 and what was paid are in the National Archives. If your family bought a farm, a house, or a business in California, Oregon, or Washington between 1942 and 1946, those same records can tell you whether the previous owner was a Japanese-American family who sold under distress sale conditions while in an internment camp. The Federal Reserve Bank of San Francisco's historical archives hold the custody records. The records are organized by property address and by owner name. They are available to researchers who request them. The War Relocation Authority records are in the National Archives under Record Group 210. They include the property surveys, the camp records, and the administrative files documenting the evacuation and its economic consequences. The individual claims files from the 1948 Act are at the National Archives. They tell the specific story of specific families. Kajiro Oyama fought for 6 years and got his farm back. His case is in the Supreme Court reporters. It established that the California alien land laws could not be used to seize land held in the name of American citizen children. It came too late for most of the property that had been lost between 1942 and 1948. Toyo Tsuyamoto's parents never got their nursery back. Their story is in the Japanese-American National Museum's Oral History Archive in Los Angeles. The $38 million paid out in 1948 represents approximately 3 cents on the dollar for what the government's own assessment said was lost. The records documenting the gap between those numbers, the property that was taken, the prices at which it was sold, the amount eventually compensated, have been in the archives since 1946. What happened to the land is in the records. What happened to the families is in the records. The gap between the two is there too, in the specific dollar amounts of distress sale conditions, 3 cent on the dollar settlements, and the post-war agricultural census that shows an industry that was built over decades and did not return. If your family bought land in California, Oregon, or Washington between 1942 and 1946, the Federal Reserve Bank's custody records can tell you whose land it was before. The records were always there. The Federal Reserve Bank of San Francisco's historical archives hold the property custody records from the 1942 to 1946 period. The records are organized by property address and by owner name. Contact information for the bank's archive is available through the Federal Reserve's public website. The War Relocation Authority records are in the National Archives under Record Group 210. The finding aid is available through archives.gov. The property surveys and the post-war economic assessments are in this record group. The individual claims files from the Japanese-American Evacuation Claims Act of 1948 are at the National Archives. They document, claim by claim, what was lost and what was paid. The Japanese-American National Museum in Los Angeles maintains an archive of internment survivor testimony, including oral histories describing the property loss from the perspective of the families who experienced it. The museum's collection is available to researchers by appointment at 100 North Central Avenue, Los Angeles. The Supreme Court case, Oyama v. California, 332 U.S. 633, 1948, is available through the Supreme Court's online database and through legal databases. It is the documented account of one family that fought and won. The records of what was taken are in the archives. The records of what was returned are in the archives. The gap between them, the specific dollar-denominated account of what the internment cost Japanese-American families, is in the same archives. Subscribe, because next week we open another file.